Okay, so good evening. So tonight we're going to be talking about legislative scope and purpose. Again, this is a very important topic because when decision makers make decisions, obviously they need to be guided by certain criteria and according to the statute, for example, and they need to be guided as well according to what the statutory purpose is. So the decision makers don't have an unlimited scope to make decisions according to their whim or even according to their own personal preferences, even assuming that they are given broad discretion by a particular legislation. So any decision that administrative decision makers make must be according to the law, and that is obviously quite a broad statement. So it's not just according to the law, but according to the purpose of the law and according to certain statutory criteria. And so we will examine that tonight in order to determine in what instances the decision of an administrative decision maker might actually be deemed unlawful, even if he can argue that his decision is actually within the bounds of the law. And so tonight, after studying this topic, you should be able to discuss and explain the three key rules that a decision maker must observe in making a decision or in exercising a statutory power, namely, that a decision maker must exercise a statutory power according to the purpose for which it was conferred. In exercising a statutory power, a decision maker must not take into account irrelevant considerations, and in exercising a statutory power, a decision maker must take relevant matters into account. So let's look at the chat. So Megan is saying, well, thank you, Megan, that you're here. Megan is saying she might have a problem trying to engage because of internet connection. So it's just going to be mainly you and me, Karen. Okay. Well, hopefully Megan can, in fact, get involved, notwithstanding problems with the internet. Okay, but I mean, you know, Megan, you could always say something without having to turn your internet on. Well, we seem to have somebody joining us now. Hang on. And this would be, so I've got a problem. Hang on. So we've got Tony. So welcome, Tony. At least we now have three of you joining tonight's session. Now, would there be any questions you might want to raise before we start touching on the discussion questions? Comments? None, so we could dig deep into the topic. Okay, so let's begin with this discussion question. The Commonwealth Development Authority Act, Commonwealth, authorized the Commonwealth Development Authority to compulsorily purchase or acquire any land necessary to meet the infrastructure needs for new roads and highways of the Commonwealth. At the CDA's Executive Committee meeting on 16 May 2013, the CDA's Chief Executive Officer proposed the purchase of a sizable property along Benwick Road that was close to an area where a multi-billion-dollar commercial complex was being developed. He noted, oh, we've got Maria now. That's good. So he noted, so there are four of you. He noted that the Benwick Road property is likely to appreciate in value as a result of the commercial development going on in the area. The proposal was approved by the CDA Executive Committee. In June 2013, Greg Harrison received a letter from the CDA stating that it was commencing negotiations with him for the purpose of purchasing and acquiring his property along Benwick Road as authorized by the Commonwealth Development Authority Act, Commonwealth. Greg does not wish to sell his property and has come to you as a solicitor for advice. He brought with him a copy of the 16 May 2013 Executive Committee meeting of the CDA, advised Greg whether there are strong legal grounds to oppose CDA's offer to purchase. So I'll give you some time to think about the question.
So could this be an unauthorised use of the powers similar to in Samarain and the Metropolitan Water, Sewerage and Drainage Board?
Why would you say that?
Because...
Oh, okay.
Well,
hey, before you do that, why don't you tell us more about that particular case? If you remember, what exactly was the ratio decidendi there? What's the legal...
Okay, well, it was a little bit similar. They were looking to purchase land so that they could expand their office buildings.
Mm.
And at the time, the judge who did the ruling said that it could have been an abuse of the board's powers if the ulterior purpose in wanting to purchase that land was a substantial purpose. Mm. So in this case, you've got the guy saying in the meeting the property is likely to appreciate in value, which doesn't really seem to say anything about, oh yes, we're going to use it to to expand a highway or something. They're talking about it increasing in money, which isn't really a purpose of the road, of roads authority. And the case in Samarain went on to say, if it was a substantial purpose in the sense that no attempt would have been made to acquire the land if it had not been desired to achieve the unauthorised purpose.
Mm-hmm. Okay. So what advice would you give?
Well, I think he could probably fight this one, particularly as it seems that those comments are reflected in the copy of the meeting minutes, that he could say it is for an unauthorised purpose.
Mm-hmm. Okay. Very good. That's actually correct. So any comments there on what Karen has said? So Karen is essentially saying that the purpose of the acquisition in relation to the CDA is actually because of its knowledge that this piece of land that is owned by Greg is likely to appreciate in value. So that is what is motivating the purchase of the land. It's not primarily to meet the infrastructure needs for new roads. So it might possibly, the purchase of the land might possibly help meet the infrastructure needs, but in terms of the main purpose of the acquisition, it is actually mainly speculative, in the sense that they're hoping that this purchase of the land will lead to a profit because the value of the land will appreciate at some point. Okay, any questions on that? So because the purpose of the purchase of the land is motivated by something ulterior, although it is possible to argue that the purchase is intended to meet the infrastructure needs for new roads and highways of the Commonwealth, but the primary purpose of the purchase is actually ulterior, in the sense that the CDA is hoping that it can profit from the potential increase in the value of that road. And because of that ulterior motive, it then makes the motive inconsistent with the purpose of the legislation, which is to meet infrastructure needs, and therefore, for that reason, that then makes the decision illegal and invalid. Questions there? Are we clear? Now, let's assume that when the CDA board is still following the same facts, let's assume that in the course of the meeting, okay. Let's assume that in the course of the meeting, what actually happened was that, there were those who argued that the purchase of the land was necessary because it would be needed for infrastructure needs. And at the same time, the chief executive officer of the CDA also mentioned that, in fact, it would be a very good idea to actually purchase the land because he is aware that that piece of land is likely to increase in value because of a potential $1 million commercial complex that is being developed. So in other words, apart from the fact that the purchase is made because it is likely to meet the infrastructure needs for new roads and highways of the Commonwealth, the decision makers considered the fact that the value of that property was likely to appreciate as well. Okay, because obviously if you have a meeting, you do discuss the pros and cons of purchasing a specific property. So in the course of the meeting, it came out that one of the reasons why they wanted to purchase it was that the property is likely to increase in value. What would happen if these came out in the minutes of the meeting? So on the one hand, it could be argued that the purchase is made according to the statutory purpose because of the need for new roads. But at the same time, in the meeting, the decision makers, in fact, considered the possible increase of the land, the value of the land, as one of the reasons why they would, the purchase should go on. What would you then say?
Well, I suppose it might depend on how the other board members reacted.
Mm-hmm.
You know, you have, I know, 10 out of 12 people saying, oh yeah, that's a great idea, we can use the money.
Mm.
Then clearly that implies that the ulterior purpose is there, as opposed to someone saying, oh yeah, that's a thought. It's like, it was one of the cases I read, I can't remember which one it was, and they were talking about how a judge might consider a red herring, turn it over, and then put it to one side. And so, you know, it's something they've considered, but it isn't a driving part of a decision. I can't remember what case that was. Maybe Pico Wallsend?
Yeah, that's right. Versus Minister for the Environment. Very good, yes. So that is right. I mean, when decision makers arrive at a decision, they obviously have to consider various factors, and they play in their minds various reasons for arriving at a decision. Some of those decisions, some of the motivations for the decision will probably be in accord to the law. Some of them may not be. But the mere fact alone that they thought about other motives, other reasons for a decision, which may not be consistent with the legislation, does not v-shape the quality or impair the quality of the decision making. For as long as the primary, Maria had to go. For as long as the primary motive for a decision by decision maker is still in accord with the statutory purpose or the criteria that should be used, that will not impair the validity of the decision maker. So in that case, as correctly pointed out by Karen, it's according to the case of Paco Wilson versus Minister for the Environment. It often happens that decision makers do turn over and examine every single aspect that would require a decision. But that alone will not mean that will impair the validity of the decision. It only means that's part of the way the decisions are made. You do evaluate the different dimensions of something that requires to be decided on. Okay, questions? None? Okay, so we could move on. Very good. Thank you, Karen. Discussion 21. Now, under the National Business Risk Assessment Agency Act of 2012 Commonwealth, the National Business Risk Assessment Agency, or NBRAA, was created to examine, review, and assess business risks to Australia and provide policy recommendations in the area of business risks to the federal government. The Act also empowered the NBRAA to review its statutory mandate, broaden the scope of its purpose, and make every regulation necessary or convenient to be prescribed for carrying out or giving effect to this Act. In May 2013, the NBRAA Executive Board concerned about human rights violations and security threats in Afghanistan, Iraq, and Syria, passed the Restricted Commercial and Business Activities Regulations of 2013, which imposed huge fines on any Australian business that conducted or engaged in any new business or commercial activity in any of those countries, meaning Afghanistan, Iraq, and Syria, without its prior written authority. The Hotbed Startup Proprietary Limited sought approval from the NBRAA to sell its products in Syria. When the NBRAA refused to give its approval, the company challenged the agency's legal authority to pass the regulations, and in its letter to the company, the agency pointed out that under the NBR Assessment Agency Act of 2012, it had broad and unqualified powers to validly pass the contested regulations. Hotbed Startup Proprietary Limited has approached you as a solicitor for advice. Advise the company whether it has a legal ground to challenge the decision of the NBRAA. Would Tony or Amanda or Jessica wish to pick up the mic? Or Megan? So what we will notice here that the Act gave broad powers to the NBRAA to actually review its statutory mandate, broaden the scope of its purpose, and make every regulation necessary or convenient. So there is a delegated authority to the NBRAA to broaden the scope of its purpose. And so the NBRAA Executive Board in this instance is arguing that on the basis of the mandate of the delegated authority under the Commonwealth Act, it has felt it necessary to require prior written authority from the agency for those who wish to conduct activities in Afghanistan, Iraq, and Syria. So what do you think? If Hotbed Startup Proprietary Limited approached you as a solicitor for advice, what would you advise the company?
I think they may have overreached their powers in making that regulation.
Yes.
National business is not really meant to be concerned about human rights and security threats, and that's what we have other departments for.
Yeah.
And so it might be one of those cases where the statute has failed to expressly and clearly state its purpose, and therefore it doesn't mean that a power conferred on it is unlimited and unqualified, and they're probably going to have to go to the good old statutory interpretation and look at the long title and the second reading speeches and that sort of thing to see what the aim of the Act was in the first place, as to whether it can really subsequently make regulations to cover this sort of thing.
So thank you, Karen. So let's clarify that. Thank you very much. That's very good. So let's clarify that. So on the assumption that the Act seems to be quite silent as to what the mandate might be of the agency, what actually happens then? So it means that, does it mean therefore that the agency will have broad and unfettered and unlimited powers, given the fact that there seems to be a broad provision here enabling the agency to even broaden the scope of its purpose? So that's not the way it works.
So you've got, for instance, the case of TUI ex parte, the Northern Land Council, where they tried to use their powers to limit, I think it was Aboriginal land rights around Darwin.
Yes.
And that was when they used the statutory interpretation to rein it in a little bit.
So that's right. Again, Karen is correct in the in this particular instance. So that even if the statute may actually be silent as to its purpose, even if the statute may actually appear to give broad, unfettered, unlimited powers to an executive decision maker, it doesn't really mean that the administrative decision maker, therefore, has unfettered powers or unlimited powers. At the end of the day, the courts will need to examine whatever might be the implicit purpose of a statute, because we have to realize that every single statute that is likely to be passed by the Commonwealth Parliament will always have a purpose. Okay? So there will have to be a purpose. I mean, it's unlikely for the Commonwealth Parliament to pass a law without really articulating, without even knowing or identifying the purpose of a statute. There is a purpose behind every single statute. So even if the statute may be silent as to its purpose, that will not lead to an assumption, therefore, that the executive to whom certain powers are given then has unfettered discretion or unlimited powers. The exercise of those powers will still be limited by what would be the implied purpose or the implicit purpose of the statute. So that will require statutory interpretation, for example. And that can mean if the law itself does not expressly indicate what its purpose might be, it might have to mean going back to whatever legislative records might be in the course, for example, of initial submissions or in the course of any debates that occur in the course of seeking a particular statute to be passed in the Commonwealth Parliament. Okay. Now, very good. Now, the other question that is probably pertinent here is that it also often happens that a statute may actually have purposes that conflict with each other. And obviously these are, and I'm very glad that Karen obviously went through the notes and perhaps even went through the book, which is really good. So it's possible that certain legislation that would be passed by the Commonwealth Parliament have conflicting purposes. So for example, if you look at the Freedom of Information Act, on the one hand, it has as a goal trying to provide opportunities for the public to have access to information held by the Commonwealth government. But on the other hand, it does have restrictions. Under the Freedom of Information Act, for example, those which might involve police matters or which might involve national security cannot be the subject of any freedom of information request. So in a situation such as this, where you have a conflict in the purposes of a statute, how then would a decision maker, when faced with a need to make a decision, how would a decision maker make a decision on the given the fact that there might be conflicting purposes in the statute itself? What would be the proper approach? Would it mean, therefore, that either way he can do what he likes? So, for as long as what he does might fall within one of the purposes of the statute, which might be in conflict with another purpose, then the decision maker would be making a decision in accord with the law. Was that clear? So there are multiple purposes for as long as the decision maker makes a decision on the basis of one of those purposes, which obviously might be in conflict with the other purposes within the statute, then the decision maker would have been within his power to make that decision. After all, it is still within among the purposes of the statute. Is that the law in relation to administrative decision making? Do you think?
Is this the one where Schleisky, or however one pronounces it, and the Minister for Immigration and Ethnic Affairs applies?
Go on.
So I've got to admit I didn't quite understand that bit.
Speaking of the ulterior or improper motive that is behind the decision. If you're studying that particular case. So in that particular case, in the case of Schleisky versus Minister for Immigration and Ethnic Affairs, it was actually within the power of the minister to make the decision according to the purpose of the law, but there was an ulterior motive behind it because he could have actually exercised his decision clearly according to what the law said. And while it was also within his discretion to make the decision that he did, still the fact remained that actually the decision making he came upon was manifestly unreasonable. And because it was actually tainted with kind of an ulterior motive. So even if a decision of a decision maker might fall within the statute, and there is in fact discretion that is given to him, it's still possible, such as the case of Schleisky versus Minister for Immigration, that the decision making is actually manifestly unreasonable in the sense that given the factors, circumstances of the case, despite the discretion, there is only actually one proper way of arriving at that decision. So that if the decision maker makes a decision under the circumstances which is just different from what should have been proper, then in that case, the decision would have been manifestly unreasonable. And in that case, we come across what we'll examine later on as Wensbury and reasonableness, which is a common law ground for an application of to review a decision, and which is also now a statutory ground under the Administrative Decision Judicial Review Act of 1977. So it's not that case that I'm talking about. Okay, because that was different. There was an ulterior motive, and secondly, even if the discretion was exercised, the exercise of the discretion was manifestly unreasonable because on the basis of the circumstances, there was actually just one proper way to arrive at a decision. So therefore, to arrive at a decision which was different, that would have been manifestly unreasonable. Now, in this particular case, the question really is that you sometimes have legislation where there are varying purposes. So if you look at the Social Security Act, which can run to thousands of provisions, you will then realize that that particular statute actually has various purposes, and many of those purposes might actually conflict with each other. So I go back to my question, assuming that when a decision maker makes a decision on the basis of a statute which has multiple purposes, would it mean, therefore, that he would be within his power to make a decision according to one of the purposes, according to any of the purposes, in other words? So if you had 5 purposes within the statute, for as long as your decision could be grounded on one of the purposes of the statute, then you have exercised your power according to the law. Is that the way that decisions should be made by decision makers in that particular case? What do you think? Okay, so in answer to that particular question, in resorting, to, for example, to rules of statutory construction, it will still be imperative for the decision maker to actually examine the primary purpose of the statute. True, a single statute may have multiple purposes, but there is often a primary overriding purpose of the statute, especially when there are conflicting purposes of the statute. So you will get a sense of what the primary purpose is of the statute. So in that case, therefore, it will not be sufficient for the decision maker then to just say that his decision is in accord with one of the purposes. That is not sufficient. At the end of the day, he has to make a decision according to the primary purpose of the statute. Now, the only time when he or she can make a decision that may not be in accordance with the primary purpose of the statute is if there is a specific statutory provision which directs the decision maker to act in a particular way. Because in that case, the discretion of the decision maker would have been clearly circumscribed. But otherwise, if there is, in a sense, a broad discretion on the part of the decision maker in relation to the decision to be made, he still has to be motivated in his decision making by the primary purpose of the statute. Okay, questions? I only have 2 questions for tonight, especially because, well, it's almost Christmas in 3 days. I was thinking that, and I'm sure a lot of you will be quite busy as well in terms of trying to finish the group assessments. So if you have any questions, then I'm happy to answer them. Otherwise, we're going to end tonight's session for the first time quite earlier than usual.
Actually, I had a question about the group assessment, please, Manjo. If you could just clarify.
Yes.
So one person from the group is going to post the questions in Moodle, the scenario question 1, scenario question 2, scenario question 3.
Yes.
And then all 4 of us submit it as a Word document with the group's names on it.
Yes.
Is that correct?
That's correct.
Okay.
So when you make a submission actually in Moodle, not only do you have the factual background with your names, but you also include the 3 discussion questions, right? Now, when you place that information in Moodle, you're going to have to repeat the factual background in each of the discussion forums because of the limitation of Moodle. So you need to repeat every single factual background and then come up with the discussion questions. And then, you agree among yourselves as to who might answer the questions or comments from your peers. I don't think it's actually possible. I don't see any problem with all of you wanting to put in your own answer. There should be no problem with that.
Okay, thank you for that.
Okay. Comments, questions before we end tonight's session? So we're good. Okay. So thank you very much again for being at tonight's session, and all the best in your group assessment, which is due on Saturday, and have a Merry Christmas. And I'll see you next year. Thank you. Bye.